Every driver reading this has said it. Maybe last Tuesday. Maybe yesterday morning. Red lights in the mirror, window down. Before the officer even finishes asking, you said it like a shield. I'm sorry, I'm just running late for work. Felt reasonable? Felt human? Felt safe? It was none of those things. I'll break down exactly what that statement hands a trained officer, 4 separate pieces of legal information, each independently useful against you, and the one alternative that satisfies the social pressure without giving courts anything to act on. The gift you didn't know you gave. Think about why that sentence comes out the way it does. You are not lying. You are not hiding anything. You are doing what every person does in an uncomfortable moment. You reach for the most relatable, sympathetic explanation available. You're late. That's not a crime. You work. You're in a hurry. The officer is human. If you just explain, maybe he cuts you a break. That instinct is universal. It does not matter what kind of car you drive, how old you are, or where you're from. It does not feel like a disclosure. It does not feel like an admission. It feels like de-escalation, which is exactly why nearly every driver reaches for it. Here is the problem. The officer at your window is not processing your words the way another commuter would. He is a trained observer running your statement through a professional framework. What registers to him is not a relatable story. It is a data package. In those 4 words, you delivered 4 distinct pieces of information he did not have 30 seconds ago. His body camera captured every word. His report will reference it. In any subsequent proceeding, what you said belongs to the record permanently. You thought you were humanizing the stop. You actually briefed the officer in a way no experienced defense attorney would ever recommend. 4 facts in 4 words. When you say, "I'm late for work," a trained officer receives 4 specific inputs. First, you disclosed a destination. Work is a named category of location. You have a route and a place you are expected. That destination becomes a reference point the officer can probe for inconsistencies. Second, you disclosed time pressure. The word late is not just emotional color. Federal Law Enforcement Training Center roadside interviewing documentation identifies driver urgency as a behavioral indicator relevant to the reasonable suspicion analysis. Under United States v. Socolow, innocent behaviors taken in combination can amount to reasonable suspicion. Urgency goes on that pile. Third, you made a distraction admission. Whatever triggered this stop, you just provided context suggesting your attention may have been divided. That context helps the officer's account of your driving survive a suppression challenge. Fourth, you disclosed a motive. Rushing due to employment obligations is now on the record. Motive anchors the other 3 observations into a narrative. And narratives survive suppression hearings in ways that isolated facts often do not. 4 facts, 4 words. Stay calm and do not reach for that explanation. How destination gets used against you. Under Rodriguez v. United States, a traffic stop cannot lawfully extend beyond the time needed to resolve the original violation. Officers cannot legally keep you there to fish. That protection is real. But destination changes the analysis. When you provide a destination, you open a line of inquiry the officer can frame as naturally flowing from the stop itself. A court reviewing whether a detention was properly extended will look at what the officer had to work with. A 7th Circuit federal case analyzed by Lexipol illustrates the mechanism. A driver disclosed his travel destination and route at the window. The trooper found the destination inconsistent with the route by several hours. The Court of Appeals found the driver's own statements about his travel plans were, quote, a weighty factor in establishing reasonable suspicion to extend the stop. What the driver said about where he was going became the legal foundation for the extended detention that produced the evidence used to charge him. Stay calm. Provide your documents. When the officer asks where you're headed, your response is, I invoke my right to remain silent. That closes the destination question before it can open. Nothing about your route, your workplace, or your schedule goes on record. The urgency signal in officer reports. I'm late carries specific professional weight. Federal Law Enforcement Training Center documentation identifies driver urgency as a behavioral indicator in the roadside interview framework. Someone who is rushed is less guarded about what they say next. Officers are trained to recognize this and to keep the conversation moving while the window is open. The legal foundation is United States versus Sokolow. The Supreme Court held that behaviors innocent in isolation can, in combination, amount to reasonable suspicion. The threshold courts have set is described as not particularly high. Your urgency indicator contributes to the stack. Here is what a report can look like. The driver appeared agitated and stated she was late for work. Her demeanor was consistent with elevated distraction. She volunteered the information without being asked. Every sentence is accurate. You provided the agitation. You provided the statement. You confirmed the distraction. None of it required fabrication. That paragraph travels through every stage of the case. The body camera shows your expression and tone when you said it. A prosecutor reads the report before charges are decided. Stay calm. The urgency stays off the record if you never produce it at the window. The distraction admission. When you say, "I'm late," you are not just describing urgency. You are providing context for why your driving looked the way it did. That context can be used against a challenge to the stop itself. A suppression motion argues the officer lacked justification for the stop. Your attorney challenges the observed violation. Then the prosecutor introduces what you said at the window. "I'm late for work." Your own words on body camera, providing context that your attention was divided when the alleged violation occurred. Courts have been explicit that driver-supplied context carries evidentiary weight. The totality of circumstances analysis, foundational since Terry v. Ohio, and confirmed in Illinois v. Wardlow, includes statements the driver voluntarily provided. You cannot go back and unsay what the body camera recorded. Provide your license, registration, and proof of insurance. Those are required. Narrate your hand movements so the body camera captures compliance. Stay calm and be respectful. What you do not do is explain the driving behavior that triggered the stop. "I invoke my right to remain silent" is the phrase that keeps your distraction admission off the record entirely. The combination problem. Individually, none of the 4 pieces of information "I'm late for work" delivers would move the legal needle. Destination alone is not suspicious. Urgency alone is not suspicious. Distraction context alone is not suspicious. Motive alone is not suspicious. Officers, prosecutors, and courts know this. But reasonable suspicion law does not evaluate factors in isolation. It applies the totality of circumstances standard, established in United States v. Cortez and reaffirmed unanimously in United States v. Arvizu in 2002. Arvizu held that courts cannot examine each factor independently. The question is whether the aggregate of all factors, viewed through an experienced officer's training, justifies the stop or its extension. This is the combination problem. You did not deliver 4 innocent facts. You delivered 4 stackable factors. The officer has a destination to probe, a behavioral urgency indicator, contextual support for the observed violation, and a motive tying the other 3 together. That stack can cross the moderate chance threshold that courts have set for reasonable suspicion when none of those factors would have crossed it alone. I invoke my right to remain silent. 4 words that replace 4 words. Opposite legal result. 2 stops, 2 outcomes. Stop 1. A driver is pulled over for following too closely. The officer approaches. The driver says, "Sorry, I'm running late for work. I have a shift starting soon." The officer notes the destination and the urgency. His report documents agitation, time pressure, and a workplace destination. When the officer asks about the route, the stated workplace does not align with the highway the driver is on. He extends the stop to clarify the travel inconsistency. A federal appeals court finds the extension justified in part because the driver's own statements created the discrepancy that supported it. The extension produces the evidence used to charge him. 20 seconds of explanation gave the officer the legal thread he needed. Stop 2. A different driver, same violation. Documents come out, hands visible. When the officer asks where she's headed, she responds, I'm happy to provide my documents, but I do invoke my right to remain silent. No destination, no urgency indicator, no distraction admission, no motive on record. The officer writes the citation. The stop ends. The body camera records a cooperative driver who provided required documents and stated a constitutional right clearly and without hostility. Same violation. Same officer question. The first 20 seconds determine everything. The alternative that works. The alternative is not silence. Under Salinas versus Texas, silence without explicit invocation does not carry the same protection as a stated invocation of the Fifth Amendment right. You cannot simply stop talking and expect constitutional protection to attach automatically. The alternative is a structured response that acknowledges the officer, provides what the law requires, and shuts down the four-part information stream without any hostility. When the officer asks where you are going, what's going on today, or why you were driving the way you were, you respond, "I'm happy to provide my license and registration, officer." That is the sentence. Not a comma and then more. Complete statement. Cooperative in tone. No destination, no urgency, no distraction admission, no motive. If the officer pushes, "I just need to know where you're headed," your follow-up. "I invoke my right to remain silent on questions beyond my documents." Stay calm. The body camera needs to capture a driver who was respectful, provided required documents, and asserted a constitutional right. That is the record you want. "I do not consent to any searches" closes the Fourth Amendment exposure if the encounter escalates. "Am I free to leave?" forces the officer to define the legal status of the stop. The alternative takes the same social energy you would spend on explaining yourself and redirects it into a phrase that costs you nothing legally. What you handed over. Here is the full accounting of what "I'm late for work" delivers, so the weight of it is clear the next time that sentence starts forming. You handed over your destination. It goes in the report. If your route or timing creates any inconsistency with other facts, that destination is now a discrepancy in the record. You handed over your urgency, a behavioral indicator that goes on the totality of circumstances pile. You handed over a distraction admission, your own words, captured on body camera, providing context that your attention was not fully on the road at the moment of the alleged violation. That is the government's evidence, delivered by you. You handed over your motive, and motive connects the other three into a narrative that is harder to suppress than isolated observations. State law creates some variation in how aggressively these factors get used. In Texas, Ohio, and Florida, courts have been more receptive to stacked behavioral factors and stop extensions. In California and Washington, courts have applied somewhat closer scrutiny to those accumulations. But the body camera record exists and travels through the case regardless of jurisdiction. The phrases protect you everywhere the same way. Stay calm. Am I free to leave? I invoke my right to remain silent. I want an attorney. I do not consent to any searches. Those four replace the four-word explanation that costs you everything. This is educational content only, not legal advice. Consult a qualified attorney in your state for your specific situation. Like this video and subscribe so this legal education keeps reaching people who need it before their next stop. Hype this video right now if you think drivers should know their rights before they face this situation. One tap spreads this to someone who needs it.